This is the Baker Act Training Guardian Advocate Module 3. In this module, I'll identify and describe the individual rights that are protected under the Baker Act and the Guardian Advocate's authority and responsibility to assist in protecting those rights. In this module, I'll discuss each of the individual rights as presented on this poster and defined in the related statutes and rules. This chart provides an overview of the Baker Act process for both the voluntary status and involuntary status. In each situation, the R marks individual rights that are protected under the Baker Act. Every individual that's admitted to a designated receiving or treatment facility or ordered to treatment at a service provider is to be given a written description of their rights at the time of admission. It's recommended that they use this form CF-MH3103. A copy of the rights statement signed by the person evidencing receipt of the copy shall be placed in that person's clinical record and shall also be provided to their guardian or guardian advocate, representative, or healthcare surrogate or proxy. To assure that individuals have current information as to their rights, a copy of the Florida Mental Health Act, Chapter 394, Part 1 of the Florida Statutes, and the Mental Health Act Regulations, Chapter 65E-5 of the Florida Administrative Code, are to be available and provided upon request in every psychiatric unit of each receiving and treatment facility and by each service provider, and upon request shall be made available for review by any person, guardian advocate, representative, or healthcare surrogate or proxy, the administrator or designee of the facility, or the service provider are to make physicians, nurses, and all other direct service staff aware of the location of these documents so that they are able to promptly access them upon request. I will specifically identify these rights with the symbol shown here and describe the rights in detail throughout this training. It's helpful to read or explain to a patient who cannot read the rights of person statement form and all of the details of their rights. Remember that poster outlining rights of individuals while receiving mental health services is to be placed immediately next to a telephone which should be available to persons that are served by the facility or the provider. A copy of the rights statement, Form CF-MH3103, signed by the individual evidencing that they have received a copy of it, needs to be placed in the patient's clinical record and also provided to the person's guardian advocate, representative, or healthcare surrogate or proxy.
Nothing works here. Nothing works here. The medications don't work. I hate this place. I've been here for 7 years. Nothing works here. The medications don't work. I hate this place.
Can you hear me at all?
Nothing works here. Nothing works here.
Can you tell us anything else that might be helpful to you?
I hate this place.
It is the policy of this state that the individual dignity of the patient shall be respected at all times and upon all occasions, including any occasion when the person is taken into custody, held, or transported. Procedures, facilities, vehicles, and restraining devices that are utilized for criminals or those accused of crime shall not be used in connection with persons who have a mental illness, except for the protection of that person or others. Persons who have a mental illness but who are not charged with a criminal offense shall not be detained or incarcerated in the jails of this state. A person who is receiving treatment for mental illness shall not be deprived of any constitutional rights. However, if such a person is adjudicated incapacitated, then their rights may be limited to the same extent that the rights of any incapacitated person are limited by law. Treating individuals with respect is the first right that's listed here. Each individual must be given recognition of their personal dignity and individuality. Each staff member should review and know these rights. Applying information goes a long way in promoting respect. Respect includes such small acts as knowing what name the resident wants to be called. Probably not honey or sweetie, but more like Mr. Jones or Brian if that is what they like. Be polite and kind to everybody, even those who are rude and disrespectful. Knock or announce yourself before entering an individual's room. Even if the door is open, ask, "Can I come in?" and wait for an okay to do so. Always provide visual privacy in personal care. In order to effectively work and to respond appropriately to the needs of each individual, it's important that you have a basic understanding of human behavior and what influences it. Human behavior is very complex. However, we do know that behavior is typically a response to an event or a feeling about something. Behavior usually represents a response to several different things. Consequently, it's often difficult to sort out which factors contribute to specific behaviors. We also know that behavior is not random. People do things for a reason, even if they are not aware of the reason, cannot describe the reason, or deny why they're doing it. Also, people usually behave in a certain way to satisfy basic human needs, such as the need for survival, affection, self-esteem, and/or self-actualization. We know, too, that human behavior is learned, predictable, and changeable. There are three elements of behavior which are helpful to keep in mind when discussing these behavioral issues. All behavior has meaning, even if it is sometimes hard to determine what that meaning is. For example, you may observe a person pacing. The person could be experiencing a great deal of anxiety, and pacing provides some comfort. However, the person may also be experiencing akinesia, a side effect of some psychiatric medications causing an involuntary restlessness. Second, behavior has a cause and effect, even though neither may be readily apparent. For instance, a person may become angry and begin yelling at someone who's sitting in their usual place at the dinner table. However, the real reason for their behavior may be unrelated to the situation. When a person expresses anger by yelling, others may respond negatively to them by avoiding them or becoming angry themselves. Third, a person's behavior is affected by their physical environment and/or other people. For example, a person may be frightened by some shadow or noises that are outside of their room, or they may begin to pace because they're cold. The social setting in which the person lives also affects behavior. A person who was living alone may be overwhelmed by the number of people with whom they're now sharing common living space, and they may withdraw to cope with this change. Each person is unique. Their signs and signals might have a different underlying cause from the ones that you suspect. This is often the case when people have different past experiences, and particularly where cultural differences are large. This is why it's important to check that your interpretation of someone else's body language is correct. You might do this through the use of further questions or simply by getting to know that individual. Procedures, facilities, vehicles, and restraining devices that are used for criminals cannot be used with individuals with a mental illness, except for the protection of that person or others. A restraint is defined as equipment that immobilizes or reduces the ability of a patient to move their arms, legs, torso, or head freely. This doesn't include orthopedically prescribed devices. It's also could be a drug or medication used to manage or restrict a patient's behavior or freedom of movement that is not a standard treatment or dosage for that patient's condition. Restraint or seclusion may only be used when less restrictive interventions have been determined to be ineffective to protect the patient, a staff member, or others from harm. A restraint or seclusion order can only be issued for the management of violent or self-destructive behavior that jeopardizes the immediate physical safety of that patient, a staff member, or others. There are time limits for restraint and seclusion orders. After 24 hours, a physician or other licensed independent practitioner who's responsible for that patient's care cannot issue a new restraint or seclusion without first conducting an in-person assessment of the patient. Management and personnel of the facility's treatment environment shall use positive incentives in assisting persons to acquire and maintain socially positive behaviors. Each designated receiving and treatment facility shall develop a schedule of daily activities listing the times for specific events, and this needs to be posted in a common area and provided to all persons. Interventions such as the loss of personal freedoms, loss of earned privileges, or denial of activities otherwise available to other persons shall be minimized and utilized only after the documented failure of the unit's positive incentives for the individuals involved. Facilities are to ensure that any verbal or written information provided to persons must be accessible in the language and terminology that the person can understand. Freedom of movement is a right of persons in mental health receiving and treatment facilities. Any restrictions of this right requires a physician's order based upon risk factors. Each receiving and treatment facility needs to have policies that describe freedom of movement and access to the grounds. When a suitable area is immediately adjacent to the unit, then the staff needs to afford each person an opportunity to spend at least 1/2 hour each day in an open, out-of-doors, fresh air activity area, unless there's a physician's order prohibiting it, and this has to have documentation in the clinical record what the clinical reasons are to not allow it. Of course, if there's inclement weather, then it's another reason not to have someone outside. The Federal Americans with Disabilities Act, or ADA, requires that accommodations be made so that all persons with disabilities can benefit from the services available to non-disabled persons. The Baker Act requires that each facility post notices stating that provisions of the ADA apply and include the name and telephone number of a person to contact for further information. Persons with disabilities related to vision and hearing must be served with accommodations made by the facility to ensure that interpreters or assistive devices are available. Persons relying on walkers, crutches, and canes must be provided with other assistive devices, such as wheelchairs, if the other device is not allowed for documented safety reasons. Persons with certified companion animals must be served and accommodations for their animals provided at the facility. Persons with any disability as defined in the ADA must be served if accommodations are possible. Each individual will be asked to identify a person to be notified in case of an emergency. If the individual is at the facility for involuntary examination and does not have a guardian appointed by the court, then they will be asked to designate a person of their choice to receive notification of them being in the facility unless that individual requests no notification be made. If an individual does not or cannot designate a representative, then a representative will be selected by the facility from the list of prioritized persons. If the individual does have the right to be consulted about the person that is selected by the facility and can request that such a representative be replaced. A representative does not have the right to authorize treatment for an individual in a facility or to access confidential information other than that which is listed here. For the most part, a designated representative is not an active role, but rather ensures an individual has someone outside of the facility aware of any legal measures taken regarding that individual. The information that representative does have access to would have to do with the right to receive notice, right to receive a copy or disposition of the inventory of personal effect upon the individual's admission, and to request an amendment to the inventory. Also to be able to receive a copy of the individual's clothing and personal effects if not returned to the individual, or to approve an alternative plan, and any petition for involuntary placement that's been filed with the court. In terms of the court, they have the authority to petition on behalf of that individual for a writ of habeas corpus, and also to petition to apply for a change of venue for the involuntary placement hearing, and to be informed by the court of the individual's right to an independent expert evaluation. Orders for emergency treatment, ETO, without consent can only be issued when an individual's behavior creates an imminent danger to themselves or others. ETOs can be for psychotropic medication, seclusion, or other restraints. Only a physician can issue ETOs, which must authorize the least restrictive treatment intervention possible. An order cannot exceed 24 hours in duration and must be documented in the medical record. ETOs may be renewed after the 24-hour point if the individual remains in imminent danger. If a second ETO is given within a 7-day period, then a petition must be issued for a guardian advocate. An involuntary examination may be initiated by one of three ways: a circuit court judge, a law enforcement officer, or an authorized mental health professional. At any time and without notice, a person that's held in a receiving or treatment facility, or a relative, friend, guardian advocate, representative, or attorney, or the department on behalf of such person may petition for a writ of habeas corpus to question the cause and legality of such detention, and to request that the court order a return to the writ in accordance with Chapter 79 of the Florida statutes. Each patient held in a facility shall receive a written notice of the right to petition for a writ of habeas corpus. At any time and without notice, a person who is a patient in a receiving or treatment facility, or a relative, friend, guardian advocate, representative, or attorney, or the department on behalf of that person, may file a petition in the circuit court in the county where the patient is being held, alleging that the patient is being unjustly denied a right or privilege granted herein, or that a procedure authorized herein is being abused. Upon the filing of such a petition, the court shall have the authority to conduct a judicial inquiry and to issue any order needed to correct an abuse of the provisions of this part. If the treatment team imposes any restriction on whom a person in a receiving or treatment facility can communicate with, such restrictions and justifications shall be recorded in the person's clinical record. Immediate access to a telephone shall be provided to each person requesting to call their legal counsel, Florida Abuse Registry, Florida Local Advocacy Council, or Disability Rights Florida. Each person receiving services in a facility providing mental health services under this part has the right to communicate freely and privately with persons outside of the facility unless it's determined that such communication is likely to be harmful to that individual or to others. Each facility shall make available as soon as reasonably possible to that person receiving the service a phone that allows for free local calls and access to a long-distance service. A facility is not required to pay the cost of a patient's long-distance calls. The telephone needs to be readily accessible to the patient and be placed so that the patient can use it to communicate privately and confidentially. The facility may establish reasonable rules for the use of this phone, provided that the rules do not interfere with a patient's access to the telephone to report abuse. Each patient admitted to a facility under the provision of this statute will be allowed to receive, send, and mail sealed, unopened correspondence, and no individual's incoming or outgoing correspondence shall be opened, delayed, held, or censored by the facility unless there's reason to believe that it contains items or substances which may be harmful to that person or others, in which case the administrator may direct reasonable examination of such mail and may regulate the disposition of such items or substances. If the treatment team imposes any restriction on whom a person in a receiving or treatment facility can communicate with, then this restriction and justification needs to be recorded in that person's clinical record. Facility staff need to make competent adults aware that they have the ability to waive the confidentiality of their presence in a receiving facility and allow all or specified individuals the person selects access to private and open communication with that individual. The guardian advocate may receive and act on notices of restriction of communication and or visitation. Written justification for restriction to communicate or to receive visitors must be given to the individual, their attorney, and guardian advocate or legal representative. The form is to be included, as I said, in the clinical record and is to be reviewed at least every 7 days. The guardian advocate should examine the restrictions to determine if it is fair and appropriate. Each facility shall establish reasonable rules governing visitors, visiting hours, and the use of telephones by patients in the least restrictive manner possible. Patients shall have the right to contact and to receive communication from their attorneys at any reasonable time.
Jeff is in a receiving facility which is also a hospital. He was treated for a medical condition. His family's visit occurred after posted visiting hours and was disruptive to staff and other patients near Jeff's room. Jeff's family refused to leave when asked by nursing staff. The charge nurse called security and had Jeff's family escorted from the ward. Did this violate Jeff's right to have visitors? Correct. Visiting hours are based on the needs of residents and their visitors and shall minimize interruption of the individual's treatment program schedules. The visiting hours must be posted in places where residents and visitors frequent. In this situation, the visitors were visiting after hours and displaying disruptive behavior. Note: visitors may request exceptions to posted visiting hours with the unit director or treatment team leader.
An individual is entitled to receive services that are suited to their needs, which are administered skillfully, safely, and humanely, with full respect for personal dignity and integrity. Each person will receive the medical, vocational, social, educational, and rehabilitative services that their condition requires for them to live successfully in the community. The availability of such services is subject to funding from the Florida Legislature. Every patient entering treatment shall be asked to give express and informed consent for admission or treatment. If the patient's been adjudicated incapacitated or found to be incompetent to consent to treatment, express and informed consent to treatment shall be sought instead from the patient's guardian or guardian advocate. If the patient is a minor, then express and informed consent for admission or treatment shall be also requested from the patient's guardian. Expressed and informed consent for admission or treatment of a patient under the age of 18 shall be required from the patient's guardian unless the minor is seeking outpatient crisis intervention services. Express and informed consent for admission or treatment given by a patient who is under the age of 18 shall not be a condition of admission when the patient's guardian gives express and informed consent for the patient's admission. Informed consent is comprised of two separate elements. The first element is disclosure. The physician must disclose all necessary medical information to the guardian advocate so that they can make well-reasoned treatment decisions. The physician must also answer questions about the proposed and alternative treatments. The second element is consent. Based on the disclosure provided, the guardian advocate decides whether or not to provide consent for the proposed treatment. The guardian advocate should only sign a consent or other authorization form after receiving disclosure information from the physician or the medical staff. Usually the doctor has made a diagnosis and is recommending certain immediate actions. However, you certainly want more information upon which to make your decision as guardian advocate. Such information would include the benefits and the risks of the procedures, other alternative treatments, and the probable outcome of these options. If the treatments were to be given over several weeks, then you would want to review the progress being made and maybe request changes in the treatment if you were not satisfied with the recovery. You might also refuse medications that the doctor ordered if they're making the ward feel worse. Maybe nausea or dizziness or confusion. Under these circumstances, the doctor might want to order the person to take the recommended medications. Since the doctor cannot order medication without the express and informed consent, except in the emergency situations, then you might want to negotiate with the doctor about what alternative medications or treatment changes might be more comfortable or less uncomfortable side effects for your ward. While this may be stressful, the guardian advocate should not blindly trust someone else with the person's health, regardless of how well qualified, trained, or respected that professional might be. If the doctor repeatedly refuses to meet with you or refuses to listen to or explain things to you, you may decide that it's necessary to request another doctor. That another doctor to assume the primary treatment responsibilities for the person's care. Remember, as the guardian advocate, you will stand in that individual's place and need to seek out this information and make the decision about their care when they cannot do so for themselves. Other individual treatment rights include treatment in the least restrictive yet appropriate manner possible, no delay or denied treatment due to an inability to pay, a physical examination within 24 hours of an authorized healthcare by an authorized healthcare practitioner, an individualized treatment plan that must be completed within 5 days after arrival, a schedule of daily activities that's posted in the facility, and the person must be allowed to assist in preparing and reviewing the plan. The plan must have space for that person's comments. Each facility will provide a therapeutic milieu that supports a culture of recovery and individual empowerment and responsibility. The health and safety of the person shall be the primary concern at all times. Seclusion or restraint shall be employed only in emergency situations when necessary to prevent a person from seriously injuring themselves or others. Patients shall have the opportunity to participate in the preparation of their own treatment and discharge plans at receiving and treatment facilities and by service providers. In instances when the person refuses or is unable to participate in such planning, then this refusal or inability is to be documented in the person's clinical record. Comprehensive service assessment and treatment planning, including discharge planning, shall begin the day of admission and shall also include the person's case manager, if any, the person's friends, family, significant others, or guardian as desired by the person. If the person has a court-appointed guardian, then that guardian shall be included in the service assessment and treatment planning. When an individualized treatment plan requires intervention beyond the existing unit rules of conduct, then the person must be included, and the person's treatment plan needs to reflect documentation, behavioral information, and data collection. Documentation includes signed by the physician that the person's medical condition does not exclude the proposed intervention, and consent for treatment is to be provided. A general description of the behaviors requiring the intervention, and this may include previous emergency interventions. There should be an arrangement for consistent collection and recording of data, analysis of that data, and based on the data analysis, development of intervention strategies. Also, periodic review and revision of the plan based on that data collection and analysis.
Can Paul's legal guardian, his father, revoke his consent to Paul's treatment once the treatment period begins? Any consent for treatment may be revoked orally or in writing before or during the treatment period by the person legally authorized to make healthcare decisions.
I think people have this fantasy that there's going to be a drug, that if you can just find the right drug, and it's much more complicated than that, because this is a woman with a life and a story who is more than just a sum of her symptoms.
She asked, why am I sick? And that biology wasn't the answer she wanted. It was like, no, why am I sick? What did I do?
Yeah.
And no one here can answer that.
During one's time as guardian advocate, there may be reasonable differences of opinion with the doctor or facility personnel. In most instances, these can be resolved by discussion. If a serious situation exists, then the guardian advocate must promptly determine the immediacy of any danger to their ward. If serious, then immediately advise the unit director or shift supervisor so that they can correct the situation, then make a written note of the event. All persons residing in state mental health treatment facilities are protected by the rights that are detailed in the Baker Act. Grievances may be written or verbal. They should detail the issue and remedies sought, and they can be addressed to any staff person. They should be date stamped by the unit director or the treatment team leader. The guardian advocate can question the legality of the individual's detention, report abuse of the individual's rights, or report abuse of procedures under the Baker Act. It is the responsibility of the guardian advocate to file grievances with the facility when the individual's rights are violated or a privilege is unjustly denied. It is the guardian advocate's duty to inform the unit director of any apparent violations, preferably in writing, and keep a dated copy for your records as well. Persons in mental health facilities have several means to question the legality of their detention, to report abuse of their rights, or report an abuse of procedures under the Baker Act. There are several agencies or processes listed here that they can use to file such complaints. All formal complaints shall be tracked and monitored for compliance. The investigation shall be completed within 7 days from the date of entry into the tracking system, and a written response will be given or mailed to the person receiving services within 24 hours of the disposition. The individual acting on behalf of the person receiving those services will be notified of the completion of the investigation, but they will not be given the details of that disposition unless they have a legal right to the information or a signed release for that information in place. As another safeguard, Florida's Medical Practice Act states that failure by a physician to provide patients with information about their rights and how to file a complaint are grounds for disciplinary action against that physician.
Mary has been abusing her phone privileges. She has repeatedly called 911 because she is upset about her confinement. Her phone usage has been restricted and the reason has been documented by the facility. Now, Mary requests to place a call to the Florida Abuse Registry because of this restriction. Can the facility restrict this call? No. At no time shall there be a restriction of telephone access to her legal counsel, the Florida Abuse Registry, local or statewide advocacy councils, or the Advocacy Center for Persons with Disabilities.
Each person receiving mental health treatment in any facility shall have ready access to a telephone in order to report an alleged abuse. The facility staff shall orally and in writing inform each patient of the procedure for reporting abuse and shall make every reasonable effort to present the information in a language the patient understands. A written copy of that procedure, including the telephone number of the Central Abuse Hotline and reporting forms, shall be posted in plain view. The department shall adopt rules providing a procedure for reporting abuse. Facility staff shall be required as a condition of employment to become familiar with the requirements and procedures for the reporting of abuse.
Upon your last visit to the mental health facility, you notice bruises and red marks on the arms of your ward. The medical staff is unable to explain how these bruises and marks came about. You are suspicious that abuse may be involved. Who should you contact? The Florida Abuse Hotline is part of the Department of Children and Families. Its purpose is to investigate allegations of abuse, neglect, or exploitation of vulnerable adults. It should be noted that other agencies like Agency for Healthcare Administration, Circuit Court, Florida Mental Health Institute may also be to assist with suspicions of abuse.
If you feel that the situation places the person in serious danger or is not being responsibly corrected in a timely manner by the facility or staff, then promptly contact the proper authorities requesting their investigation and help. If you describe the apparent unsafe or illegal situation in writing to the unit director or to the hospital administrator, then you have a copy when the investigating authorities ask for your documentation. Always keep a copy for yourself. There are several sources of help and assistance. Some of these resources include the local advocacy council, the Agency for Healthcare Administration, the Department of Health, Florida Adult Protective Services, the Department of Children and Families, the Mental Health Services, Disability Rights Florida, the Public Defender, the Circuit Court, and family support and advocacy groups. Florida law supports the right of any adult to decide what medical and mental health treatment they will receive unless that person is determined by a judge or doctor to be incompetent to make such decisions. Competent adults have the right to prepare an advance directive specifying the mental health care that they want or don't want, and designating a healthcare surrogate to make treatment decisions in times of psychiatric crisis. A mental health advance directive is a legal document in which a person states his preference regarding mental health care before a crisis occurs that might make that person unable to understand the treatment choices or make decisions. A mental health advance directive is a good idea for a person to take an active role in their care. This advance directive should name a healthcare surrogate to make mental health care decisions if the person's unable to do so in the future. An alternate surrogate can also be named in the event that the original surrogate's unwilling or unable to perform their duties. A healthcare surrogate is authorized to consent to treatment according to the advance directive or make other decisions which they believe that the person would have made under circumstances if they were capable of doing so. The healthcare surrogate will likely be appointed by the court as the person's guardian advocate under the Baker Act if one is needed. In addition to making mental health care decisions, a surrogate or proxy is authorized to perform the following on behalf of the individual. They can apply for government benefits, access the person's clinical record, authorize release of information in clinical records, and authorize a transfer to another facility. In addition, the healthcare surrogate or proxy has no authority to make any financial decisions on behalf of the individual. If disagreements arise with the decisions made by the healthcare surrogate or proxy, then the patient, their family or physician, the healthcare facility, or any other party that's affected by the surrogate's decision can ask the court to intervene under the circumstances that are listed here. A competent individual can change or revoke an advance directive at any time by signing and dating a written statement revoking the directive, destroying the directive, informing others that a change or revocation is desired, completing a new directive, or stating a specific time for terminating the directive.
An advance care directive is also known as an advance directive or a living will. Essentially, it's a document that you fill out when you're competent now that deals with your health and personal care in the future should the time ever come when you're not able to make decisions for yourself. Just like a will is a document that deals with the disposal of your personal property after you're dead, an advance care directive deals with how you'd want to be treated, your health care, your personal care, where you'd want to live, if the time ever comes when you're not able to make decisions for yourself. It's a document that you fill out when you're capable to cover a time of incapacity. You can have two types. You can have one where you name somebody to make decisions for you, or you can actually give instructions. Ideally, you want both. Ideally, you want to have an idea of what you want and then sit down with your proxy and tell your proxy what you want. So when the time comes, the proxy can say, oh, I discussed this with him. I know what he wants. This is what we should do. You'd never want to do an advanced care directive and name a proxy and not discuss your wishes with the proxy, because then when the time comes, the proxy wouldn't know what you want and the proxy would be in a terrible predicament.
A person's right to the possession of their own clothing and personal effects shall be respected. The facility may take temporary custody of such effects when required for medical and safety reasons. Each designated receiving and treatment facility shall develop policies and procedures governing what personal effects will be removed from the person for reasons of personal or unit safety, how they will be safely retained by the facility, and how when they will be returned to the person or other authorized individuals. Policies and procedures shall specify how contraband and other personal effects determined to be detrimental to the patient will be addressed when not returned to that patient or other authorized individual. An inventory of personal effects shall be witnessed by two staff and by that patient, if able, at the time of admission, at any time the inventory is amended, and at the time that the personal effects are returned or transferred. A person is entitled to possess their clothing and personal effects. If the facility takes the custody of their personal effects or items for medical or safety reasons, then a copy of this inventory must be provided to the guardian advocate. All items must be returned upon transfer or discharge either to the individual or to the guardian advocate. Use of special clothing for identification purposes, like surgical scrubs or hospital gowns to identify persons who are in need of specific precautions or behavior modification restrictions, is prohibited as a violation of individual dignity. Prison or jail attire shall not be permitted for persons admitted or retained in a receiving facility except while accompanied by a uniformed law enforcement officer for purposes of security. Under non-psychiatric medical circumstances, use of special clothing may be ordered by the person's physician on an individual basis. Documentation of the circumstances needs to be included in that person's clinical record.
Bob is a 27-year-old male who currently lives with his parents and has displayed symptoms of depression over the past month. Today he told his parents that he wants to die. Bob was taken to the nearest Baker Act receiving facility for evaluation. The unit staff required Bob to change into scrubs. Everyone admitted to the facility are required to wear scrubs until his or her evaluation is completed. Bob told the hospital staff that he did not want to change his clothes. Can the facility require Bob to wear the scrubs until the evaluation is complete? Under non-psychiatric medical circumstances, use of special clothing may be ordered on an individual basis by the person's physician. In this situation, everyone admitted to the unit is required to change. The scrubs were not used to identify Bob.
Persons have the right to register to vote and to cast a ballot in any election unless the court has removed this right. Each patient who is eligible to vote according to the laws of the state has the right to vote in the primary and general elections. The department shall establish rules to enable patients to obtain voter registration forms, applications for absentee ballots, and absentee ballots. Each patient shall have the opportunity to participate in treatment and discharge planning and shall be notified in writing of their right upon discharge from that facility to seek treatment from the professional or agency of the patient's choice.
The individual being held for examination or treatment was scheduled to be released from the mental health treatment facility yesterday. However, she was not released. Your phone messages left with the medical staff and administrators at the facility have not been returned. At this point, you are concerned that she is being held against her will without legal authority. Note: a petition can be filed with the circuit court to question the legality of a person's detention in a facility, the denial of a right or privilege, or that a procedure authorized in the Baker Act is being abused.
A notice of release is to be given to the patient's guardian or representative, to any person who executed a certificate admitting the patient to the receiving facility, and to any court which ordered the patient's evaluation. Persons have the right to seek treatment from the professional or agency of their choice after discharge from a facility, unless ordered by the court into involuntary outpatient treatment. Discharge from a facility cannot be conditioned on the individual's agreement to attend a specific aftercare program recommended by the facility, staff, or physician unless it is ordered by the court. The guardian advocate is not responsible for the individual's financial affairs or securing housing in the community after discharge. The department is directed to implement a continuity of care management system for the provision of mental health care. Through the provision, the client and case management, including the client referred from state treatment facilities to community mental health facilities. Such system shall include a network of client managers and case managers throughout the state, designed to reduce the possibility of a client's admission or readmission to a state treatment facility. The department is directed to develop and include in all contracts with service providers measures of performance with regard to goals and objectives as specified in the state plan. The department shall report to the Agency for Healthcare Administration any violation of the rights or privileges of patients or of any procedures provided under this part by any facility or professional licensed or regulated by the agency. The agency is authorized to impose any sanction authorized for violation of this part, based solely on the investigation and findings of the department. Any person who violates or abuses any rights or privileges of a patient is liable for damages as determined by the law. Anyone who acts in good faith in compliance with the provisions of this is immune from civil or criminal liability for their actions in connections with the admission, diagnosis, treatment, or discharge of a patient to or from a facility. However, this section does not relieve anybody from liability if they commit negligence. Any interested person, including the ward, may file a suggestion of restoration of rights with the court. This must state the person is currently capable of exercising some or all of the rights given to the guardian advocate, meaning that the person is no longer in need of a guardian advocate. Some evidentiary support must be included in the filing of the suggestion. Such evidentiary support includes a signed statement from a medical, psychological, or psychiatric doctor who has evaluated the person. If no evidentiary support can be accessed, then the petitioner may state a good faith basis for suggestion. The court shall immediately set a hearing. This concludes the coursework for Module 3. Do you know the intent of the Baker Act? What rights are included under the Baker Act? And who is protected by it? Can you describe the involuntary admission process? Who is authorized to represent a patient? What rights do individual patients have? Are restraints permitted? If you can answer these questions, you may feel ready to move on to the knowledge review. If not, go back and review the content of this module and then take some knowledge review. You are now ready to complete the knowledge review. Go back to the M3 tab and click open the Module 3 Knowledge Review. After completing the knowledge review, you may decide that you need additional study of this information, and if so, then go back to the beginning of the module. If you correctly answer 16 out of 20 questions on the knowledge review, you may choose to go on to the next module. Return to the home page and click open Module 4.